all of you. This is Dr. Acharyulu.
Good morning, sir.
This is Dr. MLN Acharyulu, School of Paramedical and Allied Health Sciences, AP Campus. Welcome all of you to this webinar in Forensic Sciences for the topic Law in Context by Edward Ranjit G. Jadhav, sir, Bombay High Court, Maharashtra State. Sir, welcome, sir, on behalf of Centurion Technology and Management, Andhra Pradesh.
Sir. Please wait. VC is joining.
Yeah.
VC is joining. Please wait. Just now I had called. Sir. Hello, sir. VC sir.
Join?
Sir will join now. Just now I had talked with Ram Babu.
Sir, join?
Sir. No, he'll be joining. Wait.
Okay.
Yeah.
Kind request to the Chief Guest, sir. We are waiting for our Honorable Vice Chancellor, sir. Ranjit Jadhav, sir.
Yeah. Sir had joined. Sir.
Good morning, sir. Good morning.
Yeah, namaskar.
Good morning, sir. Namaste, sir.
So, welcome all of you to this webinar in Sciences for the topic Bombay High Court, Maharashtra State. Here with us our Honorable Vice Chancellor, Prof. GSN Raju, who is an internationally renowned electronics and communication professor, having produced more than 450 publications and 55 PhDs. Now I request our Vice Chancellor, sir, to please Honorable VC, sir. Honorable VC, sir. I request you to please give the inaugural address.
Chief guest has joined.
Yes, sir.
Hello?
Yes, sir.
Yes.
Yes, sir.
Yes,
Ranjit
sir.
is there.
Yes, sir. He's there.
Okay, let me speak a few words.
Yes, sir.
Good morning, Ranjit G.
Good morning, sir. Good morning.
Good morning. We are very happy to invite you to this wonderful webinar. And knowing your background, I felt extremely happy. Wonderful background, wonderful profile. You are a great expert in your subject and a very versatile personality. I cordially invite you to deliver a talk, and our Centurion University is very fortunate to have you here today. Thank you, sir, once again. We'll be in touch with you. Mr. Vilas Chavan will be in touch with you. We'll work together. Thank you very much, sir.
Thank you.
Right.
Thank you very much, sir. Now I request our beloved registrar, Professor P.S.V. Ramanarao Garu, to please give his address.
Sir, Honorable Vice Chancellor, sir, and today's guest is Sri Ranjit G. Yadav Garu and other faculty members, Dr. Acharyulu Garu, Krishnamurthy Garu, and Mr. Vilas. First of all, I would like to congratulate the Department of Forensic Science in AP campus, who came forward to have this kind of webinar. So congratulations to the organizers and Acharyulu Garu, now you can proceed.
Yes, sir. Thank you very much, sir. So may I request Sri Amulya Behera, sir, the Dean School of Forensic Sciences, Bhubaneshwar campus, to please give your address, sir.
Actually, sir is busy with some other meetings.
Okay.
Go ahead, don't waste time.
Sri Dr. Nagajogi garu.
Acharyu,
Yes, sir.
proceed. Do not waste much time.
Yes, sir. Yes, sir.
Let
Now I
the
request.
chief guest
Yes.
take more time to present.
Okay, sir. Now I request Vataparthi Pravallika, Assistant Professor in Forensic Science, to please.
Good morning, one and all. It's honor for me to introduce our today's guest,
Over to
Advocate Ranjit Jadhav, sir. He is currently practicing law at Bombay High Court and Nasik Session Court, Maharashtra states. He got a silver medal in LLM at Savitribai Phule Pune University, Pune, Maharashtra. Advocate Ranjit Jadhav, sir, has qualified UGC SET exam in the subject of law. He is one of the top scorers in the JMFC, that is, Courts of Judicial Magistrate of First Class exam. He has delivered more than 100 lectures to various law enforcement agencies and universities. I heartily welcome you, sir, for today's webinar. Handing over to Acharyulu, sir.
Thank you, Pravallika, for your nice introduction. May I request Sri Ranjit Jadhav garu to please start his lecture, sir.
Good morning, all of you. Am I audible?
Very good. Yes, sir.
Okay, sir. I will start. Good morning, all the forensic aspirant. I am more delight. मुझे बहुत खुशी हो रही है कि एक सारे forensic experts के सामने आज मैं law in context इस topic पे I am going to guide you little bit. As मुझे भी ऐसा लग रहा है कि मैं खुद अपने घर में आ गया हूँ क्योंकि yes, I was the student of forensic science. I have did my bachelor's in forensic science in 2013 to 2016. I'm going to deliver you. I'm going to went through different subheadings relating to present topic, that is law in context. First of all, we are going to see the definition of law. Then there are various kinds of law. Then what is the difference between criminal and civil law? Then what is the hierarchy of Indian legal justice delivery system? Then who is the expert in the eye of law? What are the provisions relating to the expert in the Indian Evidence Act, under the Code of Criminal Procedure, in the Indian Penal Code? Then we are going to see what are the lacunas in the present investigating system, that is investigating machineries. What are the lacunas in the investigating machineries? Then what are the stages of trial? There are different stages of criminal trial. There are different kinds of trials, that is like session, trial before court of session, trial before judicial magistrate of first class court, trial of summons cases, trial of warrant cases. So there are different kinds of trials. Then what should you do as a forensic science student in order to achieve success in upcoming days or in upcoming time? What should you do? What should you read? What should you went to the material, different kinds of material? What kind of different materials you should use, you should read in order to achieve success? That I'm going to go through it. Then what is the evidentiary value of the forensic science? That is the forensic evidences. We know the forensic evidence, medical evidence. What is the evidentiary value of that? And last but not the least, what are the challenges, upcoming challenges before the forensic science students in the upcoming era? So these are some subtopics which I am going to cover in my small lecture. So first of all, we must know the heading of our today's lecture is law in context. In order to understand that concept, first of all, we should know what is law. So there are different definitions of law. When you are studying science, life science, applied science, as a forensic science is applied science, then the person who studies the science, who used to make discovery in the science, is known as scientist. And the person who used to study the law, who used to develop the law, is known as jurist. So there are different definitions laid down by the different jurists. That is law. According to John Austin, who is one of the jurists, law is a command of sovereign and having sanction behind it. Law is a command, according to him. According to Roscoe Pound, he is one of the jurists. According to him, law is an instrument of social change. So, but in general, we can understand the definition of law as law is a set of rules laid down by the sovereign for the governance of its people. Law is a set of rules laid down by the sovereign for the governance of its people. Now, set of rules hai, sovereign hai, and for the governance of people. Now, who is a sovereign? Sovereign means independent. There are two kinds of, we can say, dictatorship is there and democracy is there. So, in dictatorship, in a country who is ruled by the dictator, the sovereign, for them, sovereign is a dictator. But in democratic country, sovereign is we the people of India are sovereign, because Indian constitution, preamble of Indian constitution says that we the people of India, so we are independent. And in our democratic country, there are two kinds of government basically, that is state government and central government. So this sovereign used to make the set of rules for the governance of people. So for us, agar if there is no, imagine the country where there is no law existed. For the country where dictatorship is there, for them dictator is the sovereign. For the country democracy is there, for us state government is there and central government is there, who used to frame the law for the governance of people. So this is a simple and basic definition of law. Now, if we crudely see, there are two branches of law. One is civil law and another is criminal law. So what is the difference between them, and what is a civil law and what is a criminal law? First, we must understand. So civil law governing the two parties, law applicable to the two parties, law concerning with the two parties, two persons. Suppose take an example of Contract Act. Suppose I have to sell my phone to XYZ people. Suppose take a name of Amitabh Bachchan. So I have to sell my phone. I have made a written contract with him. I have to sell this phone to you for 10,000. It give me 10,000, but I fails to give him this phone, mobile phone. So this is a dispute between, this is a breach of contract. So this is a dispute between two parties. Dispute between husband and wife. One husband wants to give divorce to the wife. So this is a dispute between, matrimonial dispute is there. Then property dispute is there. My brother is not giving my ancestral property to me, so I have filed suit against my brother. I have filed property suit against my father. So these are the, when the civil law is a law which concerns with the two parties, that is two persons. It is not that much concerned with the society. Society को उससे कुछ लेना देना नहीं है. Society don't have concern with the dispute of the two parties. Society don't have concern with the dispute between the husband and wife. Society don't have concern with the dispute between the two brothers, that is property dispute. So this is a civil law. So the civil law does not affecting the people at large. It is only concerned with the two parties generally. So it is a violation of right in personam. Right in personam. Try to understand the word personam. So it is a violation of right in personam, that is a civil law. So there are, Hindu Succession Act is there. There are lots of examples of civil law. Hindu Succession Act, there is the Indian Contract Act is there. Hindu Marriage Act is there. Indian Divorce Act is there. Parsi Marriage Act is there. There all the personal laws, all the property laws, all the contract laws are come under the head of civil laws. Then another important branch, that is the forensic science, is more concerned with the criminal law. Forensic science students, the branch of forensic science is concerned with the civil laws, but there is a lot of zeal to hear that we are working for the criminal justice delivery system. So when I was in the forensic science, that is the Government Institute of Forensic Science, Aurangabad. So there is a slogan, there was a slogan that one step ahead of the criminal. So this is a heading of our that is slogan of our institute, that is a Government Institute of Forensic Science. So criminal law. Now criminal law is a law which affecting the people at large, which affecting the society at large. Take an example of Indian Penal Code. If the person has committed murder under 302, if the person has committed rape under section 306, 376, so if the person caused dowry death under 304B, then it will cause harmful impact on the society, because it is going to create a threat in the society. It is going to create a danger in the society, in the mind of people. Therefore, it is really important. It is really important. That's why the criminal law is a law which affecting the people at large. So Indian Penal Code, Code of Criminal Procedure, these are the examples of POCSO Act, then the NDPS Act, POCSO Act, that is the Protection of Child from Sexual Offences Act. These are the examples of criminal law. There are basically two subheads of criminal law, that is a procedural law and substantive law. Now, if you look at what is a substantive law? Substantive law is a kind of law which describe the punishment for the particular offense and describe the definition of particular offense and laid down the punishment for it. This is a substantive law. Take an example of Indian Penal Code. Section 300 provides for the definition of murder. Section 302 laid down its punishment, that is life or death. So this is a example of Indian Penal Code is example. There is a POCSO Act. There is a POCSO Act. There is Prevention of Atrocities Act 1989, SC and ST Prevention of Atrocities Act. So these are the example of substantive law. Substantive law defines the offense and laid down the punishment for it. This is an example of substantive law. Now, procedural law. Substantive law, how the substantive law should be implemented or how the procedure should be followed in case of offense committed under substantive law. उसके लिए procedure क्या follow करना है? What the procedure should be followed while applying the substantive law, that is laid down in the procedural law. Take an example. I will another give 302 murder. So this is a defined under Indian Penal Code. Defined under section 300, punishment is 302. So what is the procedure should be followed in case of offense of commission of murder? It is laid down under the CRPC that you should register the FIR. As per the section 154 of CRPC, FIR should be registered. Then police used to carry produce the then arrest of the offender, that is section 41 to 60 of the CRPC. If the offender is found, then he is produced before the magistrate as per the section 57 before the magistrate within the 24 hours of arrest. So this is a again procedure. Then after the arrest, magistrate remand him to the police custody. After the police custody, after the investigation, he will remand to the judicial custody. Then he will produce before the then charge sheet is investigation is completed as per the section 173 CRPC. Charge sheet is filed. We are going to 3. We are coming on that point, but this is the procedure. That this procedure, Panchanama should be carried out, inquest Panchanama should be carried out, Panchana or spot Panchanama should be carried out. Then search of the accused should be made. So how the examination of the dead body should be made in case of murder. This procedure is laid down under the Code of Criminal Procedure. This is the CRPC 1970. This is the procedural law. Another example of procedural law is CPC, that is Code of Civil Procedure. So Hindu Succession Act, Contract Act, then in case of breach of contract, how the breach of contract, when the person what the person should do in case of, in order to have the remedy. Remedy is given under the substantive law, but procedure is given under the CPC, that is Code of Civil Procedure. then you should file the suit for specific performance. You can file the court that direct him to give me mobile, that is a suit for specific performance, or direct him to repay my 10,000 rupees. So suit for damages. This procedure is given under the Code of Civil Procedure 1908. This is a procedural law. So these are the basically two and one of the important law that forensic science student must remember, that is Indian Evidence Act. It is a both substantive and procedural law. It is a mixed law. So Indian Evidence Act is applicable to criminal proceeding also, civil proceeding also. So it is applicable to civil and criminal law. This is the most important law from the point of view of forensic science students. Now, if we see the difference between civil and criminal law, there is a difference that we have to prove the guilt of the accused in the criminal law beyond the reasonable doubt. The person must satisfy the prosecution, that is state government, victim who is representing the side of the victim must satisfy the court that only this and this person has committed the crime. No other person has committed the crime. Suppose knife have found at the crime scene. Same knife, the fingerprint found on that, and the blood which is found on the knife is the blood of the is the blood of the, suppose we have compared the blood of the victim with the blood of the blood found on the knife. So we can confirm that beyond the reasonable doubt, the person whose fingerprint was present on the knife has committed the murder of the present victim. So we have to prove the guilt of the accused beyond the reasonable doubt. And that's why if there is a little doubt remaining in the, suppose there is little lacuna, we are going to, I'm going to come to that point, what are the lacunas and how the accused are getting benefited by the lacunas which are taken place during the investigation, or which are not followed during the trial. What are the mistakes committed by the investigating machineries and the trial courts? That's why the benefit of doubt goes to the, that is a settled law. If any benefit of doubt, any doubt that this person has committed a crime, any doubt in this statement, the benefit of doubt goes to the accused and he get acquitted due to the lack of evidence. So we have to prove the guilt of the accused beyond the reasonable doubt. This is a criminal law. But under the civil law, we don't have to prove the case beyond the reasonable doubt. It is based on the preponderance of probabilities. Take an example of Ram Mandir case. We don't have a proof that there is a Ram Mandir, but archaeological survey report submitted by the Archaeological Survey of India, it is said that there was no masjid. So if we read the judgment, there is nothing is there that is going to be proved there is Ram Mandir, but there is no masjid. So there are Archaeological Survey of India, something is saying that there was a traces of Mandir found. So that's on the basis of that preponderance of probability the judgment was given. So in the civil law, there is no strict proof required that we have to prove our case beyond the reasonable doubt. There is a standard of proof required, preponderance of probabilities. थोड़ा इधर उधर हुआ तो भी चल जाता है, but you have to prove at least 60 to 70% of your case. Then court will may give the judgment in your favor if you are able to prove the case on the basis of preponderance of probabilities. That is, there is a probability that we are going to the prima facie case is in my favor. We have to convince the court on that. So this is criminal law. There is another difference. There is punishments. So chapter there is a section 53 of Indian Penal Code which talks about the punishments. There are different kinds of punishment. That is death penalty, life imprisonment, simple imprisonment, rigorous imprisonment, fine. In ancient time, there were number of barbaric punishments are there, like whipping is there, stoning is there. You know the famous scientist, that is a geologist, I think, Galileo and Copernicus, who said that the Earth is now people are imagining during the ancient time. People are saying that the earth is rectangle, but he said the earth is round. So he was punished by the people by using stoning, by throwing stone on him. So he was pelting of stone until and unless the person is died. This is a stoning. Whipping is there by using chabuk, you know, chabuk. So there is a different kinds of barbaric punishment are there, which are now abolished, but still they are. Hanging is there now present. Public hanging is not present in Indian legal system, but Iran, Iraq, like Arab countries, there is still public hanging is there. Now, if you look at the justice delivery system, there is a different hierarchy of courts, Indian legal system. First, we start with the lower court, that is a JMFC, the Judicial Magistrate of First Class. He has a power to give the punishment up to the 3 years and impose the fine up to the 10,000 rupees. But in Maharashtra, he has a power to impose the fine up to the 50,000 rupees. Then after that, Judicial Magistrate of First Class, you know, Taluka Court, Tehsil Court. He has the jurisdiction over one taluka or area, some area of taluka. So this is the lowest court in some country, in some state, that is Madhya Pradesh. There is Judicial Magistrate of Second Class also there. I have qualified Judicial Magistrate of First Class, but below that, Judicial Magistrate of Second Class is also there, who has a power to impose the punishment up to the 1 year. Judicial Magistrate of First Class has a power to impose the punishment up to the 3 years. Then there is a Chief Judicial Magistrate above the Judicial Magistrate of First Class, who used to govern or used to look over the, that is the Judicial Magistrate of First Class. Then above that, there is Assistant Session Judge. Above the Chief Judicial Magistrate, there is Assistant Session Judge, who has a power to give the punishment up to the 7 years. There is a, then above the additional Assistant Session Judge, there is a Session Judge, who has a power to impose the punishment up to the death penalty, but with the confirmation of Division Bench of High Court. You have to confirm if the Session Court wants to give the punishment, if Session Court wants to impose death penalty for the commission, suppose gang rape is there, suppose POXO heinous crime is there, rare case is there. Then now recently you have read the CBI court, I think, has imposed death penalty on the death penalty to the Yasin Malik, who is a Jammu Kashmir leader, who has participated, who has a concern with the terrorist organization. He has, but that sentence should be confirmed by the Division Bench of High Court, that is two judges bench of High Court. This judgment was given by the Session Court, that is sent to the confirmation to the Division Bench of High Court, and if Division Bench of High Court confirms that death penalty should be given, then there is the execution of death penalty. Then Session Court is there. Session Court, above the Session Court, there is High Court. In High Court, in every state, now in Maharashtra, there are one High Court, Bombay High Court, and there are 3 benches. Like Nagpur is there, in Goa is there, and one is Aurangabad is there. So these are the 3 benches. And Bombay High Court is there. I think I think Andhra, and every state has a High Court. And High Court jurisdiction is concerned with the particular state. That is a particular state. Now there are some states like Tripura, Meghalaya. Now they are having one High Court among the 3 states. So depending on the population, depending on the number of cases, there is a jurisdiction assigned to the High Court. But generally the High Court jurisdiction is over the all state. Then above the High Court, there is Apex Court, that is Honorable Supreme Court of India. And the present CJI is from South India, that is Honorable Justice N.V. Ramanna. So this is Apex Court. Now from JMFC to appeal bench to the now senior division, then appeal bench to the district court, from district court to High Court, High Court from district court appeal bench to the High Court, High Court from High Court, then from High Court appeal bench to the Supreme Court. So this is in brief. I don't have too much time to extend. I have to cover other topics also. So this is a hierarchy of Indian justice delivery system. Now, the decision, keep in mind, the decision of higher courts, that is decision of High Court and Supreme Court, is binding on the all lower courts. Now, decision of High Court is binding on all the lower courts in its territory only. Now, decision of Bombay High Court is binding on Nasik District Court. So this is known as doctrine of precedent. Decision of Supreme Court is binding on all the high courts and lower courts in India, all the tribunals in India, because it is the apex court. So this binding nature, that is the binding of decision, is known as stare decisis. That is the doctrine of precedent. If any lower court give the judgment ignoring the judgment given by the higher court, it is known as per incurium. It is bad in the eye of law. Per incurium means bad in the eye of law. This is a that's why as a practicing lawyer, we used to give, suppose you have presented, suppose you went to present some report before the honorable court, before the honorable lower court in 302 trial, that you are acting as an expert and you went before the court to present the report. So this is a report, and this court, in this case, suppose take an example, DNA is a direct evidence. It is laid down by the Supreme Court in so and so case. And if the trial court judge is not admitting that DNA is a direct evidence, you have citation, that is judgment of the Supreme Court, and you have submit that citation. That is your lawyer, that this is a judgment of the Supreme Court, and according to judgment of the Supreme Court, DNA is a direct evidence. My report is, in my report also, I have stated that DNA is a direct evidence. But if that trial court judge refused to recognize that judgment, then you can went to the appeal. You can go to the appeal and before the High Court, and you can say that the trial court just fails to obey the ratio, that is judgment of the Supreme Court. That's why the judgment laid down decision given by the trial court is a bad in the eye of law. Suppose DNA direct evidence recognize nahi kiya us trial court judge ne, then suppose the person gets acquitted, but you went to the appeal, that person is acquitted on the wrong footing because trial court has committed an error. So in appeal you can give that decision of Supreme Court, and you can say that this is a decision given by the trial court, learned trial court, is a bad in the eye of law. So this is a binding nature. This is the value of, because as a lawyer we have when I am arguing before the High Court, different High Courts, I used to deliver the citations, that is cases in relation to my case. I used to deliver the number of citations of Supreme Court to the High Court, that Mayor Lordship, Your Honor, in Supreme Court in this case has held that the bail can be given, accused can be acquitted. So similar facts का जो judgment रहता है, I used to deliver those judgment before the High Courts, and when I am arguing before the Session Court, then I used to deliver the judgments of the High Court and Supreme Court, that in this case Supreme Court held that. So this is a binding. Due to the binding nature, this trial court does not dare to go beyond the ratio laid down by the High Courts and Supreme Court. This is a value. Now coming to the provision relating to the experts, there are different provisions. Like, but basically the provisions relating to the expert is provided under section 45 to 51 of the Indian Evidence Act. Section 45 to 51 of the Indian Evidence Act talks about the expert. Now, according to the Indian Evidence Act, who is the expert? The one line, that person who is specially skilled in fingerprint, DNA, blah, 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 etc., etc. But what is meant by the person specially skilled? There is no such a criteria laid down by the law that this person, suppose the person has did the PhD, he is an expert. Suppose the person has doing the postdoc in forensic science, he is an expert. Anyone can be expert. If we read the section 47 of the Indian Evidence Act, there is a opinion as to handwriting. Now, who is expert as per the section 47? The person who is acquainted with the handwriting of the person. Now, suppose I am the person who is acquainted with the handwriting of the Vizianagaram. As I am coming in contact with him on day-to-day basis, I am seeing his handwriting. So, if court has to form the opinion whether this handwriting belongs to the Vizianagaram, then court may call me as an expert because I am the person who is acquainted with the handwriting. So there is no specific criteria laid down by. This is a This is one of the biggest problem actually. This is the biggest problem. This is the biggest lacuna, according to me, one of the lacuna, because the person who was working in the forensic science laboratory, they are 12th pass, some are they are did their graduation only, but the person who are really skilled, that is the forensic science professionals, the person who has did MSc in PhD in the forensic science, they are not getting that much employment because the unskilled, more little bit unskilled person are there who are working in the laboratory. And that's why there is no such a definition of expert, because there is no such a definition of expert laid down in the law, so anyone can be an expert. So this is one of the lacuna, I must say, in the law, in the present legal system, that uh, should be looked into by the legislature in the upcoming days. Now, coming on to the, and that is a reason behind the pendency of lots of cases. I am going through the check dishonor case, one of the check dishonor case. I have sent that sample to the, request this honorable court that this sample is not belonging to my client. Kindly send that this sample to the handwriting analysis for the forensic science lab. I have sent that sample to the forensic science laboratory Pune, and the report came after the 1.5 years. So this is a basic problem. This is the main reason behind the delay in justice delivery system. Because they are not working, there are lots of pendency of cases. What is a presumptive test? What is a confirmatory test? What test? Whether they are performing that test. I have gone to, I will not take the name of the laboratory, but I have went to that laboratory in order to some of my own case. For some of my own case, I have went to my client, and the evidences are packed in the suitcase, and there is no such there is contamination of evidences. There is no maintenance of chain of custody. If your fingerprint, so these forensic science laboratories, why there is a less evidentiary value to the forensic science evidences? Why? Because of this uh, negligence on the part of the forensic science staff or forensic science, the laboratory which are working in the area of forensic science, that should be looked into. Now, lacunas in the present investigation justice delivery system. What are the lacunas? So there is less number of laboratories. We have to admit that there are n number of cases in Nagpur. There is number of toxicology cases are pending. Number of cases are there, but little number of laboratories are there. Little number of central forensic science laboratories are there. If we read the Sunanda Pushkar case, the sample of viscera has been sent to the London for the examination. Why? Why it is sent to the London? Why it is not examined in India? Because we know that, because the Sunanda Pushkar case, because the person knows that, the government knows that the forensic science laboratories in India are not in that much developed state in order to examine such a critical or such an important evidence. So that is a defeat on our part, that the Indian government is not looking for the development of forensic science laboratories. And we are capable, forensic science students are capable, but they are ignored by the government because of the. Now, second reason behind the lacunas in present investigation system, that is lack of funds to the forensic science laboratories, lack of funds to the investigating machinery, that is police officers, because there is no funds given for the investigation. In foreign countries, like there is FBI, Federal Bureau of Investigation, they are spending a lot of money in order to give the justice to the people, their people. They are spending a lot of money, but we have a lack of funds. The police officers is not that much skilled in order to investigate, because they don't have a skill which the forensic persons have, that is collection, numbering, photography, bird eye view photography. There are the searching is method is there, the spiral is method, zonal method is there, numbering is there, then packing, handling, collection of evidences, present carrying out different tests. So if the evidence get contaminated at the collection stage. Now 2 months ago, I went to the examine one case at the police station, Nashik Road police station. Some person has committed a suicide, or maybe the person was pushed from the behind, and he came under the railway and he died. His hands were two hands were went to the different directions, and legs were went to the different directions. Police persons came there, and now we are studying that we must collect the evidences in the that suppose we must first do the barricade, then remove the unwanted people, then photography, then numbering, then collection, then packaging. The police person has appointed one bhangi, one beggar like person, and he is collecting that one leg, one hand. This is a shokantika. Yeah, this is a sadness on our part that I understand. But so at the very beginning, the evidence get contaminated, and as I previously said, if there is a lacuna in collection of, if there is lacuna in proving the guilt of the accused, the benefit of doubt goes to the accused, and he is get acquitted. So this is a lacuna in collection, lacuna in packaging from the beginning. If there is small contamination, we will not able to prove the guilt of the accused beyond the reasonable doubt. So this is a lacuna in the investigating machineries. Then I will give the example. Now another lacuna is biased investigation. He is a criminal. He has committed the crime, and police officer used to train the charge sheet accordingly that he is the person. They will take him into the police custody. You must have seen the movie Jai Bhim. So they used to take him to the police custody, and by using stick, iron rod, they used to beat him, and by using that confession, and I must say, in number of cases, the confession that if you read the section 27 of the Indian Evidence Act, that is a recovery panchanama. That is a, so the person said that I have committed the crime, and I have, by using knife, and I have hide that knife on that area. So police officer used to beat him. Nowadays practice is there. Police officer and if he said that I have hide the knife in that area, police officer, that statement is admissible as evidence in the law. So what are the police officers now doing? They are just beating the criminal, and chalo udhar, they are warning him, they are threatening him, and they used to take him to the spot and collect the knife and produce the evidence. So this is a biased investigation. One of the biased investigation. This is also lacuna in the investigating machinery, investigating system in the India. If we see the, if you must have read you have heard the news of Aryan Khan, who is getting discharged. His name is not in the charge sheet. I will not use the word discharge, but his name is not. He's not in the charge sheet. He got clean sheet. So this is a public angle, but I have read the judgment. If you read the judgment, why he has got clean sheet? On the basis of chatting, which is found in his mobile phone, which is found in the mobile phone of Arbab merchant. That chatting, on the basis of chatting, he looks to be somewhere involved in the offense. But why he has got clean sheet? Because it was the argument given by it was the argument put forwarded by the machineries that the mobile phone which is seized from the Aryan Khan was not properly seized. Just that snatched that mobile, just taken that mobile phone. The seizure procedure was not followed. The seizure procedure, we know the forensic science student that we used to follow the proper seizure procedure, that is a collection, numbering, whatever. And there is a difference between copy and imaging. We used to create an image of that mobile phone by using different recovery, RICOA, NK software in our system, and we used to work on the image. There is a difference between copy and imaging, you must be knowing. So we used to create an image of that phone, that is a cloning, imaging of that phone, and we used to examine that cloned copy, not the original copy. So original evidence was not properly collected, original evidence was not properly seized. That's why the Aryan Khan got acquitted. Sorry, a clean sheet. Then another example we must take that NDPS case. I have handling the one of the case in Goa, where the 4.5 kg of marijuana, that is ganja, was seized from my client. I went to went for his bail, and I argued before the court that as per the section 43 and 49 of the NDPS Act, the seizure must be carried out before the magistrate, and they must confirm, and it is a procedural aspect that the police officer must confirm the substance is the marijuana ganja by using confirmatory test. But they have said that we have confirmed that this is a ganja, this is a marijuana by using smelling, by smelling it. Whether smelling was is a confirmatory test? No. Then I have argued before the court that the seizure was not carried out before the magistrate. The police officer seized the substance before the marijuana from the accused, which is not done in the presence of magistrate, and I have taken that benefit of that lacuna in the investigation, and I got the bail because I have the citation. I have already said that I have the citation that Supreme Court in the case in one of the case held that Ali Asgar versus State of Maharashtra. In that case, Supreme Court held that if the seizure was not proper in the NDPS cases, seizure was not carried out before the magistrate, and accused or opportunity was not given to the accused that you are free to exercise your seizure before the magistrate, then the person may release on the bail. This was the judgment given by the Supreme Court. So this is the advantage which is went for my side while arguing and my client got bail. So this is the advantage which criminal lawyers like me and other criminal lawyers used to take. That is a advantage of lacuna in the investigating machineries. Now, role of the forensic science come in two stages. Forensic science branch of the forensic science. There are two stages basically. There is pre-trial stage and post-trial stage. Criminal trial, before the pre-trial stage is there. Now, pre-trial stage starts from the commission of offense. Now, I will come to the role of the forensic science in the pre-trial stages of the investigation or of the any kind of matter. So what is the pre-trial stage particularly? From the beginning, that is commission of crime, to the filing of charge sheet. This is the pre-trial stage. That's a taking of cognizance, up to the taking of cognizance. Now, I have already said that you have in pre-trial state, suppose any murder is committed, suppose a suicide is committed, suppose any rape is committed, then there is a verification, collection, examination. Now there is a provision relating to the examination of accused on the request of the police officers. If the person has committed a murder, if the accused person has committed a suicide, or if the accused person has committed a rape, then there is a provision in the law under section 53 of the Code of the Criminal Procedure that police officer can request the medical practitioner to examine the accused in order to collect the basic details. So he may, suppose in the cases of rape, he may have marks on his body, that is a marks of nail of the victim on his body. He may have a thread of cloth, which we know the local principle of exchange. We must there must be something exchange between the victim and the accused. There may be blood marks on his there may be blood marks on his clothes, that is the blood marks belonging to the victim. Then there may be buccal cavity marks on his body, or that is the bite marks of the victim. So bite marks of the victim in one of the, I think in Nirbhaya case also, there was a buccal cavity marks onto the shoulder or on the back side of the accused was present, and that was one of the evidence while considered by the buccal cavity marks, and buccal cavity marks of the present on the body of the victim was compared with the buccal cavity marks, that is the bite marks of the accused. and that one of the evidence which is a crucial evidence which leads to the conviction of the accused in that Nirbhaya case. Also, the lip marks was found on the beer bottle was also important in the Arushi Talwar case. Got the lip marks, that is a chiloscopy, I think, study of lip marks known as chiloscopy. So that lip marks compared with the lip marks of the accused, and that was found on the beer bottle. That was compared, and that was crucial evidence in the conviction in the Arushi Talwar murder case. So this is a pre-trial examination of the accused person by on the request of the police officer. Then is the examination of rape victim is there. Examination of accused of rape is there. Section 53A. Examination of accused of rape at the request of the police officer. The medical practitioner can examine that person. So during this examination, you as a forensic science student, you examine lot of evidences which are present on the body of the accused in order to collect collect those evidences, examine, submit the report in the court, and which lead to the conviction or which will be helpful while proving the prosecution case. So now from FIR, I already said production, then filing of charge sheet. Till the filing of charge sheet, there is Panchanama, inquest Panchanama is there, spot Panchanama is there, and during the investigation up to the filing of charge sheet, there is a different vital role played by the forensic science in the pre-trial stage. Now, role of the forensic science in the post-trial stage. From where the trial actually starts, criminal trials. There are different kinds of trial. That is summons trial. Summons trial is a trial of cases for which the punishment is below the 2 years. This is a summons trial. There is a warrant trial. Warrant trial means trial of the cases for which punishment is above the 2 years. So there is a warrant trial of warrant cases. Then there is a trial known as trial before the session court of session. So there are trial before court of session. So session court may call you in some case that produce your report on this topic. Produce your report on whether the fingerprint belonging to accused and the fingerprint present on the blooded knife is belonging to same person. May call you during the trial under section 45 of the Evidence Act in order to give your testimony, in order to record your findings in the trial. This is a basic role. This is the role relating to criminal cases, but in civil cases also. Suppose any person, there is a provision under section 76 of the Code of the Civil Procedure, that is a court commissioner. And court commissioner can be appointed for the different purpose. One of the purpose is scientific examination. Suppose I am the person, I have grown some crop that is belonging to, I have copied someone's technology, and similar crop I have developed by copying someone's technology, and I have given different name to him. So there is an issue relating to patent. Now the person has filed a case against me. So whether that my crop is of the different genetic variety or is of the same genetic variety, the court is not able to court don't have that much scientific knowledge whether the genetic variety are same or different. So court used to appoint you as a court commissioner, and court may send you to the field, that went to this area of field, collect the sample of crops, examine whether these two genetic varieties are same. It is a scientific examination. So in not only in criminal law but civil laws, in quasi-criminal cases like 138, examination of handwriting, examination of ink. 138 means check dishonor cases, whether that handwriting is of a same person, whether the name, suppose in number of check bounce cases, check dishonor cases, the person, I am the person who used to give the check to someone by using who used to give the blank check to the someone by only signing on it, and the person later on, suppose I have taken 1 lakh rupees from the Vilas sir. Suppose I have taken 1 lakh rupees, but I have give him a blank check that if I fails to repay the 1 lakh rupees to you within a 6 months, you can have file a suit against. This is a blank check for the security. I have signed on it and I have given the blank check to him. But later on, Vilas Sir's mind changed. He maliciously put 5 lakh rupees in the check. That whether that I have a signed check, Vilas Sir have filed signed check. He by using different ink, different pen, wrote his name on that blank check, and amount is put by him as a 5 lakh rupees. And he went to the bank in order to withdraw the money. But I don't have 5 lakh rupees. Check get dishonor. He sent me notice. Then after that, he filed a complaint before the court. Then I have said that I will take a stand that I have given only blank check, your lordship. But I owe him only 1 lakh rupees. But dishonestly, he put 5 lakh rupees amount onto the check. So court will say me whether you have a proof of it. Court, I will request honorable court to send that check sample to the forensic science laboratory, whether the name and amount ink and my signature ink is same. So court will say on my request, court may send that check to the handwriting expert, that is forensic science laboratory, and court may call him to give him a report, or call him personally to give his deposition that the ink which are used in the writing of name and amount, and ink which is used in the signature by delivering the signature are different. So I will get benefited that this evidence will support my contention that Vilas Sir has dishonestly deputed 5 lakh rupees amount onto the check. So this is a role played by the forensic science in the check dishonor cases also. So this is a civil cases also, in criminal cases also. Forensic science persons are used to play a very important role. Now coming to one of the important cases, that is paternity and maternity disputed cases, that is civil cases. In civil cases also, that is a paternity, who is the father of the aged children. Ye bacha mera nahi, this child is not belonging to me. If you read one of the famous case on the paternity dispute, that is a N.D. Tiwari case. One of the minister, seeing that the child, one of the 20-year-old child says that he is my father, but he told that I am not his father. So court, but now I will come to the legal problem in this paternity and maternity testing. So in paternity maternity dispute, that is civil cases also, the forensic science person, I think RFLP restriction fragment, the RFLP procedure is there, you used to do, and by using that RFLP technique, we used to electrophoresis, something is there, and by using that technique, we used to identify the father of the particular child. That is in the case of disputed paternity and maternity cases. Now coming to the please keep this mind that I'm going to come to the problem, which is a problem in the Indian legal system, lacuna in the hindrance in the Indian legal system for the conduction of test of DNA test, that is a DNA test. What is the problem in that? I am going to come to that point also. Now, as a forensic expert, we should understand how we should present the report before the honorable court. Now, there are some basic rules, basic ethos, which we should keep in mind while presenting the report before the honorable court, that is the trial court. Now, first, you should form the opinion on the basis of facts. You should form the report on the basis of facts, not on the basis of your opinion. You should frame the report, but only on the basis of facts. आपको क्या लगता है? What you are feeling? That is not important. What are the real findings? Only that real findings you should quote in your report. Suppose that blood belongings to accused, you only, and if only blood group get matches. If the DNA, you are not sure with whether the DNA of the victim, uh, blood of the victim and the blood, suppose you are not able to collect the DNA from the blood which is present on the knife, that is alleged weapon of crime, but and you are able to collect the DNA from the victim's blood. So, but you are not able to collect the DNA from the knife of the blood present on the knife. Then, but you only able to collect that the blood group which is present in the blood of the blood group of the blood which is present on the knife and blood group of the victim is same, and you are not able to draw conclusion on the DNA. So you should only quote that the blood group belongs to the blood present on the knife and blood of the victim is same, but I am not sure about the DNA. So you should only state the facts. You should not state your opinion that this blood is of the victim, but because the blood group is not a confirmatory test until and unless DNA testing is gone through. If you form the opinion on the basis of what you are feeling, not only basis of facts, on the basis of your experience, that suppose blood group matches, then victim blood is blood present on the knife. Suppose this is your experience, but only on the if you're only on the basis of experience you are going to quote, then this is a bad. This is not ethically correct, because you are going to face the criminal lawyer, that the defense lawyer, and defense lawyer may cross-examine you that on what basis you are stated that this blood is belonging to the victim. Suppose person like me, suppose I have some knowledge of forensic science, I am going to cross-examine you, and if in cross-examination you are not able to answer properly, then court may draw adverse inference. Court may draw adverse inference against your client also, that is your party, that is prosecution, and against you also. So you should frame the opinion only on the basis of facts, not only on the basis of your skill or what you should feel, what you are feeling. Then, because you are independent person, you are from no one side, you are neither side from you remember that you are independent person, you are neither supporting the prosecution, you are neither supporting the accused, because you are just an expert whose help was taken by the court in order to draw the in order to help the court, honorable court. That's why they have taken your help, and you should give your independent opinion that this is a fact and this is my report. So you should not be biased from the side of the victim or from the side of the, you should give the independent report only on the basis of facts and facts, not on the basis of what you feel. Or because because in some of the major cases like Sunanda Pushkar cases, there Arushi Talwar cases, there Nirbhaya cases, there are n number of cases who got the media trial, who got the media frame, and you are watching the TV every day. You are watching the TV that in TV that this is a person who is a very cruel person, because before the court there is a media trial. Before the declaring him the accused in the trial in the honorable legal court, that is criminal court, the media used to allegate that he is a criminal. Only he is a criminal. So only on the basis of reports of media, and if you have if you have saw the news in the newspaper, if you have saw the news on the TV channel, and you went to your laboratory and you are working and you have prepared the report, and somewhere you are in your mind that this person has committed the crime, so you have framed the report according to that this person has committed the crime, so you have ultimately submitted the bias report. You should not do so, because your opinion, your skill should not be affected by the opinion of other society or your opinion of the media. You should have your independent stand only on the basis of facts. If you are You are forensic science students. You are going to do your PG, your graduation, your PG, your PhD. After that, you may join government forensic science laboratory. You may join a private forensic science laboratory. You may establish your own forensic science lab, own forensic science firm. I am going to come to the opportunities in the forensic science. I will guide you on that. So when you are going to work in the laboratory, when you are going to work as a forensic professional, as a forensic expert, remember these things. Please don't form the biased opinion. Then prepare the report in the simple language. Very simple language you should prepare your report, because as a lawyer, as I am forensic science student, but there are lawyers who are graduated in arts. There are some judges who are graduated in arts, commerce. They don't understand the scientific language. Suppose if you I have read the somewhere Datura alba Abrus precatorius, that is poisonous seeds. If you not able to explain those what is the albus precatorius, Datura alba to the court will not able to understand. What are you saying, mister? I don't have a science background. So you should frame you should not use Shashi Tharoor's English. You should frame your report. You should write your report in the simple language. It is easily understandable. That is language easily understandable to the court, and easily understandable to the normal people and advocate and prosecutionals. You don't use too much high English while preparing the reports. In simple language, you should present your report. You should present your testimony. If you call in the court, Mr. Please give your report and please have some words on your on the basis of, please make us understand that report. And you went to the court and you are using so high English words, so scientific words, that this my lord, this. The court is going to be confused. That, mister, I am not getting anything. Please understand. Please explain us in very simple language. So that you should keep in mind while preparing the reports. Now coming to the one of the important aspect, that is a evidentiary value. What is the evidentiary value of the forensic science? That is forensic evidence. Now, as per the present Indian justice delivery system, for all the forensic evidences except DNA has only corroborative or supportive value. It is admissible in the court of law as a circumstantial evidence. Except DNA, all other forensic evidences, fingerprint, footprints, thumbprints, all are admissible as a circumstantial or corroborative evidence. So by using this setup, suppose fingerprint matches with the accused, footprint matches, his car skid marks get matches, all his face recognition get matches. So all other supportive forensic evidences, his mobile phone number get matches. All these forensic evidences get this group of forensic evidences are considered, are responsible for the acquittal or conviction of the accused. Because, and one of the important aspects, that this chain of circumstantial evidences, chain of forensic evidences must be established in order to prove the guilt of the accused beyond the reasonable doubt. I have already mentioned in starting of my lecture that you have to prove the guilt of the accused beyond the reasonable doubt. So there must be chain of, you must have read a first year student that there is a chain of custody. There should not be breakage of chain of custody. So like this, there should be chain of circumstantial evidences there. Suppose take an example that POXO, suppose 302 or POXO rape case is there. So one of the forensic evidence is that, what is one of the forensic evidence in that? That suppose you have collected, you have found the dead that rape along with murder. You have examined the accused. You found cloth traces belonging to victim found on the accused body. You have collected those traces. You have drawn the rectangle. You have counted in the rectangle how many grids are there. I have read somewhere. I remember that how the cloth belonging to victim or cloth belonging to accused was found on the victim's body. Then we used to collect that sample, and cloth, that is a shirt of the accused, and we used to examine by using microscope, that is a anti-clockwise clockwise thread. So this is one of the evidence. Then if you examine the semen sample from semen sample which is found on the victim's body, which is found in the vagina of victim, then you collect that sample, then examine that sample, extract the DNA, match that DNA with the DNA of the suspect. This is one of the semen is there. Then there might be a marks found on the body of the accused, that is a nail marks. Compare those marks with the nail of the victim. This is a third evidence. So these are the series of evidences. If you found match the blood group, match the DNA, if you is able to establish that this bite marks, these nail marks are pointing towards the accused, same accused. This semen is belonging to same accused. This blood group is belonging to same accused. This DNA is belonging to same accused. This cloth is belonging to same accused. So by using series of these circumstantial evidences are pointing out toward the same accused. And by establishing this chain of circumstantial evidences, by establishing this chain of forensic evidences, you are able to establish the guilt of the accused beyond the reasonable doubt. So by using this chain, so don't break. I have already submitted what is the lacuna, that is there is contamination, there is a failure to apply proper procedure in collection in evidences by the police officer. There is no skilled techniques or skilled treatments are used, or the skill test was not conducted by the forensic science laboratories in order to whether their tests are confirmatory or preliminary. So there is a basic problem with the contamination, improper seizure collection of evidences. If you are able to and if there is contamination, there is improper seizure, then benefit of doubt goes to the accused, he is get acquitted, because we have to prove the guilt of the accused beyond the reasonable doubt. This is a settled principle. So vital role is played by the forensic science students, forensic science professionals in the collection of evidences. There should be proper procedure, there should not be contamination, there should not be improper seizure. And if we follow this proper procedure, proper forensic science techniques in order to collect the evidences, we will surely able to establish the guilt of the accused beyond the reasonable doubt, because we will able to create the chain of the circumstantial evidences in order to establish the guilt. Chain of the circumstantial evidence should not be break. If it breaks anywhere, then benefit of doubt goes to the accused. I have already corroborative values there. Now there is one of the aspect that if there is contradiction between circumstantial evidence, medical evidence, that is forensic evidence, and the eyewitness, some of the judgments of the Supreme Courts and High Courts are saying that there is a contradiction if the opinion or report or testimony of the expert is on the basis of some skilled data, some settled principle, then it may prevail over the testimony of eyewitness. I will give you an example. In one of the case, eyewitness is saying that the firearm was used in the murder was pistol. What is the firearm used? That is a pistol. The injury was present on the body of the victim was fired from the pistol. The bullet was fired from the pistol firearm. But as per the expert, ballistic expert, it was not a pistol, but it was a rifle. Now you must have studied that what is the difference between a rifle firearm and plain firearm. Rifle firearm, there are grooves to the barrels. So in case of a rifle firearm, entry wound is smaller and there is groove, exit wound is larger in case of rifle firearm. In case of plain firearm, entry wound is larger and exit wound is smaller. So in this case, that case, the entry wound was smaller and exit wound was larger. On that basis, on the skill examination, the forensic ballistic expert submitted the report. This was the firearm which was used is not a plain firearm, but it was a rifled firearm. But the eyewitness was saying that it is a pistol. But on the basis of skilled examination, on the basis of that skill, on the basis of that data, the forensic science, the court held that the report or the testimony given by the forensic ballistic expert was on the basis of the proper explanation and skilled use by him. That's why the testimony of the forensic expert, ballistic expert, will prevail over the testimony of eyewitness also. So this is a power, this is a value which is given by the forensic science, forensic evidences by the honorable court. Then now what is a problem? I have said that ND Tiwari case, what is a collection problem is there. If you read the articles 20 subclause 3 of the Indian Constitution, that is doctrine of self-incrimination. What is the doctrine of self-incrimination? That no person shall be compelled to give testimony against himself which is going to incriminate him in some crime. Suppose any person who is should not be compelled to give testimony against himself, that testimony is going to incriminate him in some crime or in some case. He should not be compelled to give that testimony. Suppose I should not be compelled that I have committed the crime. I should not be compelled to give that testimony. That was examined. So ND Tiwari case is all about that. ND Tiwari case, ND Tiwari is taking the defense of the article 20 subclause 3, that I should not be compelled to give my DNA sample, because you know that if my DNA sample is get compared, then I have to adopt, or I have to give the share of my property to the child. But court has taken his sample and compared that sample, and court held that fingerprint, DNA, taking of fingerprint will not come under the head of article 20 subclause 3. It will not come under the head of testimony. Taking of DNA sample, it will not come under the head of testimony. Taking of fingerprint of the accused, because fingerprint may get matched with the suspected sample, that is the fingerprint of the accused may get matched with the fingerprint present on the crime scene, fingerprint present on the body of the victim. So everybody will take the defense that I should, according to Indian Constitution, I have the fundamental right. I should not be compelled to give the testimony against myself. So court held in that case also, the fingerprint will not come under the head of testimony. The police officers can take the fingerprint against the consent of the accused also, because it will not come under the head of testimony. So fingerprint, DNA, it will not come under the head of testimony. Now, one of the technique which was declared unconstitutional by the Honorable Supreme Court, that is narco-analysis, that we used to inject the blood, that is the drugs, I think sodium pentothal is there. We used to inject that sodium pentothal in the body of the victim, and he got subconscious, and we used to ask him question whether you have committed so and so crime, kindly tell us the truth. So according to the Supreme Court held that narco analysis in the case of Selvi versus State of Karnataka. Honorable Supreme Court held that in the case of Selvi versus State of Karnataka, the narco analysis technique is unconstitutional because it is violating Article 20 subclause 3, that is right to self-incrimination, which I already earlier said that this fundamental right was violated because of the narco analysis. So that test was declared unconstitutional. So any kind of testimony which was or any kind of evidence which was collected from the narco analysis technique, it is not going to be admissible in the court of law. Court will not take it as evidence if you collect the evidences to the narco analysis. So this is a narco analysis technique. Then one of the supportive techniques, that is I think lie detector test is also one of the supportive technique. Dream arithmetic test also there. So these are the evidentiary. This is evidentiary value. It is admissible as a corroborative and supportive evidences and by using series of supportive evidences, we can prove the guilt of the accused beyond the reasonable doubt. If there is a contradiction between the medical evidence and eyewitness, sometimes mostly testimony of eyewitnesses prevail, but if on the basis of skilled data by using proper explanation, forensic science expert give the opinion to the court on the basis of that settle the principle, then somewhere the testimony in some cases of the forensic science expert is prevail over the testimony of eyewitness. I have given the example of that is by murder by using pistol firearm and rifled firearm. Now, what are the upcoming challenges? Last subheading, what are the upcoming challenges for the forensic science students in the upcoming area? What are the upcoming challenges? Now, or what you should do in the future in order to achieve the success in the area of forensic science? I will must say, read at least one judgment within 8 days or 10 days involving the forensic science, role of the forensic students, because you cannot separate the law and forensic science. If you read, if you see the definition of forensic science, application of science for the purpose of justice. Justice is nothing but the law. So you ultimately you have to be part of the system, that is legal system. So that's why you should read at least one judgment, criminal judgment, civil judgment, which involves the role of forensic, or in which the forensic court recognize the value of the forensic evidences, in which the court recognized or admired the role of forensic science. You should read those cases. One book is available on the internet or Amazon, top 10 judgments of which changed the Indian judicial system. Top 10 judgments which changed the initial judicial system. You should read the criminal judgments. You should read the, so that it will help you to apply your forensic science knowledge, how to apply that knowledge in the solving the cases. It will develop your attitude, it will develop your analytical skill if you read the judgments. I also read the judgment because I have to suppose I have to handle some murder case, suppose some new case came to me, and I used to read 10 to 15 judgments relating to my case, that if I went, and because by reading that judgment, I will able to come to know the approach of the court in that case. So from start to end, court went in this way. So I came to know that I went in this way. I am going to get the success, and I came to know also what are the mistakes committed by the lawyer. So by overlapping, by ignoring those mistakes, I used to study those case laws, those judgments, and used to prepare my case. So you should read the judgments at least one judgment within 8 to 10 days. Then do not treat law as your optional subject. My friends, I am consistently telling you, law hai, optional hai, ho jayega. We will give a paper, we will see what happens, we will pass the examination. Don't do that. Read the law carefully. Read the bare acts. Now, you should, you are lazy somewhere because some students are saying to me, or some my colleagues from the other, some of my friends from the other field also say that law is a very boring subject, and there are a number of sections, number of articles, lots of judgments. How you remember those judgments? But my dear friends, you are the forensic science students. Ultimately, you have to present the report to the court, and you and forensic science and law is like a husband and wife. So you don't say you will not able to separate these husband and wife. So this is important. You should not study the law as an optional subject. Read those books. For CRPC, you can read the C.K. Takwani is there. S.N. Mishra is there. Basic book are there. For Code of Criminal Procedure, S.N. Mishra and C.K. Takwani is there. For Indian Penal Code, there is a basic book known as K.D. Gaur is there. So, and if you don't have that much courage, or that much you feel lazy in reading books, then go to the YouTube, search the legal videos. There are n number of videos available, my dear friends. N number of videos are available in relating to forensic science, relating to law, application of forensic science in law, application role of the forensic science in law. Read those, saw those videos, see those videos. Contact me in case of any difficulty, because you will able to see the legal angle of the forensic science by seeing those video, by reading those judgments. And if you able to apply that your forensic science skill in the law, you will be unstoppable. You will get great success in that. Now there is an issue of employment I am going to speak, because one of the important aspect you should do that along with your studies, please be study for the competitive examination, because you are going to be part of the system, that is CBI, CID, forensic science laboratories, NADA is there, WADA is there, or National Doping Anti-Doping Agency is there, National Chemical Laboratory, all this part of the system. You are going to be part of the system only by way of competitive examination, that is logical reasoning, English, grammar, blah 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 blah. So you have to prepare for the competitive examination in relation to the forensic science. What are the vacancies? There are a number of vacancies like scientific assistant, scientific expert, scientific officer, laboratory analyst. There are n number of vacancies in the forensic science laboratory, but syllabus is competitive examination. So there are rules. I have challenged those rules by way of PIL in the Bombay High Court. I have filed a PIL in the Bombay High Court now in order to challenge those recruitment rules. I have contended that kindly frame the syllabus of the examination as per the syllabus of the forensic science, because forensic science students are already overbothered by their syllabus and they have to prepare for the competitive examination. I have filed that PIL, but presently, unfortunately, the syllabus is like competitive examination, so you don't have any option. So along with your study, at least 1 or 2 hours in per day, you should start preparing for the examination, that is competitive examination, for the vacancies which are in the field of forensic science laboratory. Now, I am being a professional. I have already mentioned by the Vilas sir and one of the students that I have cracked the judicial first class. I was the judge, but I left that job. I got placements of 80,000 SDFC in law firms, but I want to establish my own name. So that's why I came to the practice. And now people are coming to me, sharing their problems. I'm solving their cases, solving their problems. So I'm earning okay, not I'm earning, but I'm satisfied, because I want to help the people. I want to give them some sort of justice. That's why I came to the profession. So you can establish your own firm. I have there are my lot of colleagues, lot of friends from the forensic science faculty came to me. I have helped him. I have helped them to establish their own private limited company. All the legal formalities were did by me. I helped them. I taken documents from them. I took documents from them and the I helped them to establish forensic science private limited company, and now they are in the name of that company they are giving their reports, 65B certificates, because there is judgment of Punjab and Haryana High Court. There is no electronic evidence or any chat, any recording, any electronic evidence is admissible in the court of law unless it is accompanied with the section 65B of Evidence Act certificate. उसको बोलते हैं section 65B certificate. Unless any electronic evidence is accompanied with the section 65B certificate, it will not going to be admissible in the court of law. So their 65B certificate, my friend is issuing the section 65B certificate to my clients also or other persons also. So he's earning well. He's earning more than what the government forensic science expert are earning. He's earning well. So you can establish your own company. You can establish your own partnership firm. If you don't have that much that much financial support, then you can establish your partnership firm or company by using 7 to 8 members. You can establish that partnership firm and you can work on the evidences. You can take the private cases. You can you must visit the courts, and you must your visiting cards to the court. You must have small office nearby court that I am the forensic expert. I am handling. Suppose one of the handwriting expert, one of your friend is handwriting, one is DNA expert, one is cyber expert, 3-4 friends, one is psychology expert, 3-4 friends together and establish the firm, and you have a small office. You will earn a lot. I'm sure there are number of professionals, forensic science person who are earning privately more than you can imagine in Pune, Mumbai. But you should have office in metropolitan city, because in the rural areas there is limited scope to the forensic science professionals. But as an expert, if you have to establish yourself, then you can went to the metro city. In Maharashtra, there is Pune, Mumbai is there. In Andhra Pradesh, there may be Hyderabad or Telangana. You must see, you must be knowing what is your metropolitan cases, means higher paying or highly high profile cases. You can handle those cases. Now, now last but not the least, update yourself, your dear friends. Dear friends, read the newspaper, read the legal aspect, read the scientific aspect. Suppose I have you have read the Aryan Khan case. I have read the Aryan Khan case. You have read the Ram Mandir judgment. I have read the Ram Mandir case also. But I used to see the legal angle in that judgment in the Aryan Khan case. I have said the mistake committed by the police machineries in the Aryan Khan case. So you must read. You must read newspaper. You should acquire the skill, that is speaker identification is there. Now cyber crimes are encouraging. What is a what is email spoofing, email bombing, that is a number of phishing is there. So you should, these kinds of crimes are increasing, international crimes are increasing, cyber crimes are increasing. So you should update yourself according to the nature of crime, because the nature of crime is got complex. Update yourself. There is a machine learning course is there. You should do those courses. You should my colleagues are doing well in the area of forensic science, because they along with the forensic science they did some machine learning courses, cyber courses, and they are settled in the multinational company. They are earning very well. So you should study along with your forensic science syllabus. You should clear. So fact examination is there. So you should update yourself according to the present scenario, present nature of crime. This is all from my side. I have tried to deliver you small, as much as I am having with me. I am not too old. I am just 26 years of old. So something I am having, I have tried to deliver. I try to share with you. There might be some mistakes. If there might be some mistake, then will be there. I seek sincere apology from my side. That's all about. That's all from my side for the today's webinar on law and context. Thank you, sir. Thank you.
Thank you so much.
So excellent, sir. The session you have covered all aspects, and also the rightly you have mentioned that it is multidisciplinary, and students are supposed to have the knowledge from the machine learning and other subjects also. Now the session is open for queries, my dear students and faculty members from Bhubaneshwar and AP campuses. Any of you having queries, please?
Yes, if you have any question, you can directly unmute yourself and you can speak, or else you can simply type your question in chat box. Ranjit,
Sir,
yes, sir.
please tell them to ask directly. I'm not. Chat box is
Okay, fine.
difficult.
I will read the question for you, sir. So Devendra
no problem.
Devendra has posted one question. So what is the necessary of anticipatory bail? So this is the question asked by Devendra.
The anticipatory bail, suppose any person is falsely implicated in the particular offenses. Suppose I am Devendra and me having political rivalry. I go won the election and he wants to falsely implicate me in some kind of offenses. Suppose offenses in case of rape or intruding the modesty. So he will manage some girl and he will send that girl to the police station, that give the testimony that the person has Ranjit Jadhav has did something wrong with me. So this is a false case. So in order to protect myself from the false cases, in order to those cases which are given with the political with the intention of political rivalry, in order to protect myself, I have filed the application before the Honorable Session Court. Only Session Court has the jurisdiction directly. Session Court and High Court. They don't Taluka Court or JMFC don't have jurisdiction of anticipatory bail. Under Section 438, you have filed the application for the anticipatory bail. That is protection from the arrest. So court will ask me how you are falsely implicated in the present case. So you must convince the court that I was not present at that scene. The ingredients of section 376, 375 was not getting attracted against me. I was falsely implicated. I was implicated by the victim because of the political rivalry. And you should convince the court there is no need of custodial interrogation. What is the need of arrest? There is a need of custodial interrogation by the police. So you should convince the court that there is no need of custodial interrogation because I have not committed so and so crime. I was found falsely implicated. You may show the reports. You may show the aeroplane tickets that you are not present at the spot which was mentioned in the FIR. So there is no need of arrest. There is no need of my arrest. There is no need of my custodial interrogation. On this, I am law-abiding citizen. I have a lot of reputation. If I got arrested, then it will hamper my reputation. I have family. So on number of these points, you can convince the court and you may get the anticipatory bail. Yes.
Thank you, sir.
Sir, this is a query from my side, not query, of course. Have you got an opportunity to any point of?
I am not able to.
Sir?
Yes, sir.
Actually, sir,
Please repeat your question.
Am I audible, sir?
Yes, sir. Yes.
Have you had an opportunity to advocate for any national interest things, sir?
National interest?
National interest oriented issue. Have you had an opportunity to advocate, sir?
I am now. I have filed one PIL relating to electricity issue to the farmers because in the daytime they are sending the electricity of less voltage. That Maharashtra State Electricity Board, they are sending the electricity of less voltage, and at the night they are sending the electricity of high voltage. So the farmer ultimately, in order to give the water to their crop, have to spend lot of their whole night in order to give the water to their crops because the electricity voltage is high only at the night times. So right to livelihood. So in order to set that criteria, in order to change that criteria, I have filed a public interest litigation, that is PIL, before the Bombay High Court. There are a number of farmers cases, but this is one of good case went from my side. Yes.
Ranjit sir, actually sir's question was whether you have handled any national level case till now.
No, not yet.
Okay, sir, no problem. Any challenges you have faced, sir, in your career so far? I'm very happy to say that you have given more than 100 lectures. We are very fortunate to have your lecture with us. Any challenges you have faced in your career, sir, so far in connection with forensic science?
In my legal journey or in my lectures?
Legal journey.
As an
advocate.
Legal journey.
Yes, yes.
As an advocate, I have already said that when I have started my career as an advocate, no one is believing that this child age, so small age children or less age childish. Because I have started 20 at the age of 23. I have started my career as an advocate. So no is going to believe that he's having knowledge of law, he's having forensic science knowledge. Financial crisis are there. Now I am earning a lot. It is not an issue, but belief. In order to create belief in the mind of people, it is difficult for me because of my age. Because people think that the advocate having hair loss and advocate having white hairs, white beard, he is more senior and more intelligent. Other than that, the advocate who is young, he don't have that much skill. Though this is a approach, or this is the approach of the people, general people to the advocates. Yes, sir. So
Yeah, true, sir. Yeah.
I'm getting age now. So as my age is increasing, now number of high profile cases are also increasing. So by age, I will, if I get senior like you, then I will able to get the international level cases. Sir. So this is an issue. Yes.
Yeah.
But knowledge is knowledge, skill is
Valuable
skill.
experience.
Age don't have a concern with the knowledge. So this is the issue, sir.
Yes, sir. Thank you. Thank you very much, sir. So,
Yeah.
Vilas, sir.
So there is one more question in chat box.
Yeah, yeah.
Shreyanshu Khamari has asked questions that I want to know about classification of offenses in criminal law as per criminal law.
Hey, there are four kinds of basically offenses under criminal law. There is cognizable offense, non-cognizable offense, compoundable offense, and non-compoundable offense. Now, in cognizable offense, police can arrest you without any warrant from the court, like murder, 302, 307, rape. These are serious offenses, are cognizable offenses in which the police officers can arrest you without any warrant. But in non-cognizable offense like forgery, document offense, which are less serious offense, the police have to take the permission of the court, have to take the arrest warrant from the court in order to arrest you, and the police officer cannot arrest you without having warrant from the court. This is a non-cognizable offense. One is the compoundable offense, in which there can be offense can be settled, or the matter can be settled by a compromise between the two parties. Suppose any kind of husband and wife dispute is there, wife has filed the case for 498A, that is cruelty. Or suppose I have slapped someone by mistake and he has filed the FIR for section 323, that is an offense by simple hurt, that is causing hurt by simple means. So these simple offenses, these are trivial offenses, are compoundable. So if the the complainant came before the court that I don't have any kind of complaint, or what was done, or what the complaint was filed by me under the in what we can say under the impulse. So I don't have any kind of complaint, or now don't have any kind of allegations against the accused, and I want to compromise this my case. Then there is compromise occurred between husband and wife, the complainant. In some tribal cases, this offense is known as compoundable offense, and one other offense is non-compoundable, which cannot be compromised. So serious offenses like rape. Suppose rape victim came later on and I don't have any one of the judgment, I will say now subsequent marriage cannot cure the rape. Suppose there is a living relationship between man and woman, or two girl and boy, and subsequently the girl filed suppose FIR for the commission of rape against the boy, and later on there is compromise between the family of girl and family of boy, that what happened. Now we should get married, we should commit a marriage of the girl and boy, and they went before the court that the girl is saying that I want to marry with this person, kindly take the my case back, that for the offense of rape. Court will say you, court will definitely take care of you, and court will put a fine on you, because it is not an compoundable offense. Because tomorrow anyone will commit a murder, and tomorrow you will kindly take this 1 crore rupees and compromise this case. Whether it is possible? So these serious cases are not compoundable, not compromised. These are the non-compoundable offenses. So cognizable, arrest without warrant. Non-cognizable, no arrest without warrant. Compoundable means compromise offenses which can be compromised. Non-compoundable means which cannot be compromised.
Yeah, student. Any other question?
Vilas, any please, or else we shall proceed to the next step.
Just a minute. So one more question.
Yeah.
Yeah. Question again as asked by Devendra. So in overpopulated country like India, why we can't have more Supreme Court?
Hey, it's a good question, and it was discussed earlier. Now I am handling a Supreme Court cases also. I have matters at Supreme Court, but I have to spend 10 to 15,000 by air, by flight. So it is a bar. I am living in Maharashtra. The advocates which are living in Kanyakumari, it is not feasible for them to travel to the Supreme Court Delhi and to contest the case. It is a good question, but now but we don't have that much. Now that query or that question was put forwarded by the Supreme Court to the central government, but central government as usual, we don't have funds, we don't have money, blah blah blah. But the alternative given by the Supreme Court, Justice G.Y. Chandrachud is there. He's the next Chief Justice of India. He's going to be next Chief Justice of India. Justice D.Y. Chandrachud from the Supreme Court has, during the COVID pandemic, there was no physical presence of the advocates in the courts, that is the Supreme Court or High Courts or trial courts. So advocates are attending the trial, attending the matters by using video conferencing, VC, that is VC. So the D.Y. Chandrachud has one of his cases said that the Supreme Court is become supreme by real mean, because the lawyers from the each and every part of India are representing the Supreme Court, representing before the Supreme Court. So because if there is physical hearing, only lawyers from the Delhi, Haryana and Punjab, they are coming to the Supreme Court. It is not possible for the Kanyakumari lawyer to came to the Supreme Court. So because of the video conferencing, all the lawyers from the various parts of the country are able to attend the hearing, are able to represent themselves before the Supreme Court. So now Supreme Court is now framing the procedural aspects in order to compulsorily establish the video conferencing system for the lawyers which are coming from the different states, so that they will able to attend the hearing, or they will able to contest their matter before the Supreme Court. So they are instead of establishing the another bench, they are trying to establishing the video conferencing system as in compulsory manner. Yes.
Yeah. Any other questions, students? Okay, fine. Acharyulu sir, please proceed.
Yeah. So may I request Tamosha Mukherjee ma'am to please propose for the formal vote of thanks to the advocate Sriman G sir. Over to Tamosha Mukherjee ma'am.
Thank you, sir. So to all the dignitaries present here, my colleagues and dear friends, it's my privilege to have been asked to propose a vote of thanks on this event. I, Tamosha Mukherjee, on behalf of School of Forensic Sciences, Centurion University of Technology and Management, Odisha, wants to extend my heartfelt gratitude to our keynote speaker, Advocate Ranjit G. Jadhav, for his insightful session. Thank you, sir. Next, I would like to extend the vote of thanks to respected Vice Chancellor, Sir, Colonel Professor Dr. GSN Raju, CUTM Andhra Pradesh, respected Vice Chancellor Madam Dr. Supriya Patnaik, CUTM Bhubaneshwar, Dr. PSV Ramana Rao, Registrar, CUTM Andhra Pradesh. Dr. Anita Patra, Registrar, CUTM Bhubaneshwar. Dr. Amulya Ratna Behra, Dean, School of Forensic Sciences, CUTM Bhubaneshwar. Dr. MLN Acharyulu, Dean, School of Paramedics and Allied Health Sciences, CUTM Andhra Pradesh. Dr. Gurudat Patnaik, Dean, School of Pharmacy and Life Sciences, Centurion University of Technology and Management, Bhubaneshwar. Mr. Vilas Anil Chavan, Head, Department of Forensic Sciences, CUTM Andhra Pradesh. Dr. Nagajogoya Kothakota, Head, School of Forensic Sciences, CUTM Bhubaneshwar. Professor Dr. Krishnamurthy, Dean SOET, CUTM Andhra Pradesh, for their help and guidance in organizing such an informative webinar. And also my sincere gratitude to all the faculty members who have played an important role in making this webinar successful. And last but not the least, my dear students, for attending this webinar. So with the permission from all the honorable members present here and organizers, I would like to officially declare the end of today's session. Thank you so much for your patience here.
Thank you so much, everyone, for
Thank you, ma'am. Thank you, ma'am.
Thank you, Ranjit sir. Thank you so much, Ranjit sir, for accepting our invitation and guiding our students.
Namaskar ji. Nice session, sir.
Actually, sir, your voice was breaking.
Hello.
Yes.
Yes, sir. Yes, sir.
Chancellor.
Yeah. So I invite the speaker. But now let us please extend our invitation to Sri Jadhav ji.
Yes, sir. Yes, sir.
Okay, sir. Thank you very much, one and all.
Yeah.
Namaste,
Thank you,
sir. Jadhav ji, namaste, sir.
Namaste.
If you happen to come to Vizianagaram, please come here, sir. Pay a visit to our campus. On behalf of Centurion University, I mean, thank you very much, sir. Namaste.
Thank you.
Thank you.
Namaste.
Thank you. Thank you all. Now you may please leave the meet. Thank you.